Hello everyone, welcome to ugc Academy. This is Sudipta. Today we are going to talk about Article 13. In the previous video, I have talked about some important points and case laws regarding Article 12. If you haven't watched the video, kindly go and watch it. And today I am going to talk about the second part of the revision series where we are going to talk about Article 13. I hope you have already studied the Article 13 from your notes, books and everything. And today I am going to talk about some important points and case laws that you need to remember, and side by side I hope after watching this video you are going to revise it as well. So let's start with the video, but before that, if you haven't subscribed to our channel, kindly do subscribe it, because we are going to come up with the next video on Article 14 and side by side the other necessary tips regarding CLAT LLM, ugc-nta and other law exams. So do subscribe and hit the bell icon, and let's start this video. If we talk about Article 13 and starting with it, unlike USA, India has its own judicial review article, and that is Article 13. Now, what does it contain? Article 13 basically talks about if any law abridges fundamental right, then that law must be struck down under Article 13. Now, if we start with Article 13.1 specifically, then Article 13.1 talks about the pre-constitution laws. Now, pre-constitutional laws, if they are found to be inconsistent with the fundamental rights, they will be invalid after the date of commencement of the Indian Constitution. That's what it says, Article 13.1. So, if we go back and look into the deep of Article 13.1, it's prospective in nature and it doesn't affect retrospective way, because any laws or pre-constitutional laws which is inconsistent with fundamental rights, they are not void ab initio, they are going to be invalid after the commencement of the constitution. So you have to understand its prospective nature. Now, talking about Article 13.1, there is a very important quote that has been asked in several exams, so I need to add that quote as well. That quote is given in the case of, you can write it out, that case of Madhav Menon versus State of Bombay. And in that case, it has been said that there is no fundamental right that a person shall not be prosecuted and punished for an offense before the constitution came into force. So this particular quote has been asked many times, so you can take a note of this quote, and also the case of Madhav Menon versus State of Bombay. Now, talking about Article 13.2. Article 13.2 basically a directive that state cannot make any law that takes away or abridges your fundamental right. Now, if a law takes away or abridges your fundamental right, that will be struck down or declared invalid under Article 13.2. Now, there is a huge but. If a small part of that whole law takes away fundamental right, not the whole law, but only the small part I talk about, so that small part will be declared invalid, not the whole law. And that small part will be set aside and separated from the whole law. And this particular concept is given under Doctrine of Severability. Now, this doctrine of severability can be understood by given a case example. Like in the A.K. Gopalan versus State of Madras, the first fundamental right case. In that case, Section 14 of the Preventive Detention Act was declared invalid. Now, while declaring invalid the Section 14 of the Preventive Detention Act, the whole Preventive Detention Act was not set aside, only the Section 14. Under the doctrine of severability. I hope you have understood. Now, there is also another case, that is RMDC versus Union of India. This case also important regarding doctrine of severability. Now, why it's important, you will let me know in the comment box. Now, there is also another important part regarding doctrine of severability. If the constitutional part and the unconstitutional part both are entangled with each other, that or mixed up with each other so that you cannot separate, then the whole law will be invalid, not the unconstitutional part. I hope you have understood the doctrine of severability. Now let's get into the doctrine of eclipse. If a law violates the fundamental right, it's not void ab initio. It just becomes unenforceable. It's not fully dead, but it's in dormant state. That is the principle of eclipse, doctrine of eclipse. Now, doctrine of eclipse has two applications, one in relation to pre-constitutional laws and another in relation to post-constitutional laws. Now, when it comes to pre-constitutional laws, it's very easily understood that doctrine of eclipse is applied there. But in post-constitutional laws, there is some doubt, there is some controversy. So we are going to talk about some case laws regarding that. Now, let's talk about the pre-constitutional laws. Now, doctrine of eclipse pre-constitutional laws case is Vikaji vs. State of MP. It's very important case, write it down, and if you already know it, remember it again. In the Vikaji vs. State of MP, the CP and BRR Motor Vehicles Amendment Act was amended and enacted while it was valid in 1947. But after the commencement of the Constitution in 1950, it was declared invalid because it was in violation of Article 19(1)(g) of the Constitution. Now, after 1 year, when the first amendment came and it authorizes the government regarding the monopolize any business, it actually freed the CP-BR Motor Vehicles Amendment Act 1947, and that particular Amendment Act gets revived again. So it is the basic case regarding doctrine of eclipse in relation to pre-constitutional laws. Now, in relation to the post-constitutional laws, there are three instances that I am going to mention. The first case is that Dipchand versus State of UP, where the court said the doctrine of eclipse was not applied to the post-constitutional laws. Now, talking about another case, that is State of Gujarat versus Ambika Mills, where the court said the doctrine of eclipse was applied to post-constitutional laws against the non-citizens only. And in third instance, the case is Dulod Lad versus 3rd Additional District Judge Kanpur, where the court said doctrine of eclipse applied to post-constitutional laws against the citizens as well. So this is the three instances, and these three instances and case laws are very important for your exams, competitive exams. So I hope you will remember that. We have talked about Article 13(1) and 13(2). Now let's talk about Article 13(3). Now what does Article 13(3) talk about? Article 13(3) talks about what does law include. Now law includes a lot of things like ordinance, order, bylaw, rules, regulation, notification, custom and usage having the force of law. Now this 13(3) law does not include the constitutional amendment, and that is the controversial thing we get to know afterwards, because in the several cases Supreme Court discussed about this issue, that whether the constitutional amendment is included under Article 13(3) or whole Article 13 or not. Now first, this issue came up in the Supreme Court in Shankari Prasad case, and in the Shankari Prasad case the Supreme Court said the law under 13(3) that has been included, there are a lot of things, but it does not include the amendment made by the Parliament under Article 368. Now this issue again came up to the court against Sajjan Singh in the state of Rajasthan, and the Supreme Court reiterated the same thing which it said in the Shankari Prasad case, that it does not include in the law definition that is given under 13(3). Now, in the third case, the Kolaknath, Supreme Court made the U-turn. Supreme Court said the law includes the amendment made under the Article 368. Now, after hearing a lot of things from the Supreme Court, the government came up with the 24th Amendment. And that amendment actually talks about nothing in this article talks about any amendment made under Article 368. This particular clause is added as clause 4 under Article 13. Now this clause 4 Article 13 was challenged under very famous case that you know it already. That is the case of Nanda Bharati versus Union of India. And that case, Supreme Court upheld the validity of Article 13 subclause 4. So now it is the law, Article 13 subclause 4, and the constitutional amendment under 368 is not included under Article 13. Now, this is the whole Article 13, but there is another doctrine that is left to discuss, that is Doctrine of Waiver. Now, Doctrine of Waiver, can you waive your fundamental rights? No, absolutely not. It's not open to ourselves to waive our fundamental rights, and this issue was discussed in Baseshwar versus Income Tax Commissioner. So, I have discussed a lot of case laws, lot of important points that you need to remember for your exam. CLAT PG, ugc-nta, judiciary, any other exam, law exam that you are going to appear for. Now this is Article 13, and if you like the video, give it a thumbs up and don't forget to subscribe the channel, because next week Friday we're going to talk about Article 14. So please do read first, and we're going to talk about Article 14 division part and important points and case laws. And don't forget to share this video to your fellow friends, because this video, I hope it will help them to revise their Article 13 as well. And the most important part, if you haven't known about the fact, the most affordable and comprehensive PSU and LLM program, the link is given below. In that program, we are giving 150 live classes and recorded classes, and also at least 70 mock tests are there to make you prepare all the aspects. Subjective part revisions are there, subjective part videos are there, hardcore material, softcore material, every aspect is covered. It's going to make you prepare for the PSU LLM program. The link is given below, and don't forget to subscribe to our channel. Until next time, we are going to see you again on Friday next week. Thank you. See you.